Support for today's episode comes from Amazon, sharing stories and initiatives focused on protecting water resources and strengthening water resilience in communities around the world. EPA FY2025 enforcement numbers are being read wrong by most EPAs. FY2025 enforcement numbers are being read wrong by most compliance teams. EPA released its fiscal year 2025 enforcement results in March 2026 and called them the strongest in years. The headline numbers support that claim. The underlying data, pulled apart by independent analysts, tells a more complicated story, and the difference matters for how C-suite teams should be calibrating compliance risk heading into summer. The U.S. Environmental Protection Agency, EPA, reported 2,127 civil enforcement cases concluded in fiscal year 2025, the highest count in 9 years. Criminal charges reached 156 defendants, the most since fiscal year 2016. Combined civil penalties, criminal fines, restitution, and court-ordered relief totaled over $1.2 billion. Those numbers are real. They are also in significant part a function of a single case. Hino Motors pleaded guilty in March 2025 to a multi-year conspiracy to falsify emissions data and illegally import non-compliant engines into the United States. The resolution included a $521 million criminal fine, a $525 million civil penalty, and an estimated $300 million in additional remediation commitments. That single case accounts for a substantial portion of the aggregate penalty figures EPA cited in its annual report. Take it out, and the enforcement picture looks different. Independent analysis shows administrative enforcement has become more lenient. The Environmental Data and Governance Initiative, EDGI, ran a comparison that EPA's press release did not. Looking at administrative cases concluded during the first year of the current administration, January 21st through September 30th, 2025, versus the comparable period under the prior administration in 2024, the share of cases concluding with zero penalties rose from 59% to 66%. Total federal penalties in administrative cases fell from $68 million to $54 million over a comparable calendar year period, even as the current administration concluded more cases. The EDGI analysis also found that 71% of administrative cases under the current administration imposed zero penalties in its first year, compared to 18% in the prior administration's final year. Total federal fines in cases started and concluded in the first year came to $21.6 million versus $60.3 million in the prior administration's comparable period. The case count was higher. The penalty yield per case was significantly lower. None of that appears in the EPA press release. It requires reading the underlying case data rather than the headline summary. What the numbers actually mean for compliance risk assessment. The picture that emerges from the full data set is not that enforcement has collapsed. It is that enforcement has been restructured in ways that create a specific risk profile for specific types of companies. Administrative cases, the routine enforcement mechanism used to address the permit violations, record-keeping failures, and operational compliance gaps that make up most facility-level exposure, are being resolved more leniently at the federal level. Penalties are smaller. More cases are closing with zero fines. For companies with clean programs and functioning compliance infrastructure, that is genuinely good news. For companies carrying unresolved compliance gaps, it creates a different kind of risk. The assumption that the current enforcement environment provides meaningful cover if a violation is discovered. It does not. EPA's voluntary disclosure programs received 538 disclosures covering violations at 957 facilities in fiscal year 2025. Companies running proactive programs are using the favorable environment to disclose and resolve. Companies that are not running those programs do not have access to the same pathway. Criminal enforcement is running at a different intensity than civil enforcement. The divergence between civil and criminal enforcement is worth specific attention for legal and compliance teams. While administrative civil cases are resolving more leniently, criminal enforcement produced its highest defendant count since fiscal year 2016 and resulted in forfeiture exceeding $1 billion in illegal proceeds. The criminal program opened 187 new cases in fiscal year 2025 and obtained 65 years of incarceration. The cases driving those numbers share a profile: deliberate falsification of compliance data, concealment of violations from regulators, and conduct that crosses from negligence into intentional fraud. The Hino Motors case, which involved years of systematic data falsification, is the clearest example. A wood treatment company in Oregon resulted in a $1.5 million criminal fine and a 90-day prison sentence for the company president after regulators found evidence the executive knew about illegal hazardous waste practices and actively concealed them. The relevant line for compliance leadership is not where the criminal enforcement threshold sits in absolute terms. It is where it sits relative to the decision-making inside their own organizations. A compliance gap that an executive knows about and declines to address is not in the same legal category as one that was missed. Criminal enforcement data in fiscal year 2025 suggests EPA's criminal program is active and is specifically targeting cases where intent can be established. State enforcement did not follow the federal administrative trend. The administrative leniency in federal enforcement has not been replicated at the state level. And for multi-state operators, that is the more operationally significant data point. Several state environmental agencies have explicitly maintained or increased enforcement activity in areas where federal enforcement has pulled back, using the space created by federal deference to assert their own authority more directly. California's enforcement program, under its Air Resources Board and State Water Board, has continued at full pace. New York's Department of Environmental Conservation has been active on air and water enforcement. State attorneys general in several jurisdictions have indicated willingness to use state environmental statutes in areas where federal enforcement is less aggressive. For a company that has calibrated its compliance posture against federal enforcement trends, state exposure is the unpriced risk, the compliance strategy that fits the current environment. Reading the full fiscal year 2025 enforcement picture, rather than just the press release, points toward a compliance strategy with 3 elements that are more valuable right now than they have been in several years. First, voluntary disclosure. 538 disclosures at 957 facilities in a single fiscal year is not a small number, and it reflects real financial decisions by real companies that ran the math on self-disclosure versus getting caught. Second, documentation depth. The cases resolving with 0 penalties are not going to facilities with sloppy records. They are going to facilities that can demonstrate functional compliance programs when a case is opened. Third, state-level mapping. Federal enforcement trends are not a reliable proxy for state enforcement trends in the current environment, and they have not been for at least 2 years. The Hino Motors case will eventually leave the aggregate penalty figures. What will remain is the enforcement structure underneath it. That structure is more lenient for companies running compliance programs and significantly less forgiving for those that are not. The gap between those 2 categories is wider in fiscal year 2025 than it has been in a long time. Sustainability Soundbites water coverage is sponsored by Amazon. Visit the link in our show notes to learn more about Amazon's Spotlight on Water. For sponsorship opportunities with Environment and Energy Leader, please reach out to a member of our team.